Hello, everyone. I'm Ugo Taddei, the lead lawyer of the Clean Air project within ClientEarth, and together with me today, I'm joined by Matuszewski from our Warsaw office. And
thank you, Ugo.
And we're going to kick off today a series of webinars on the right to clean air and access to justice as part of a live project on access to justice in environmental matters. In the first seminar today, we'll discuss about standing and who can go to court to protect the right to clean air. And then in the following two seminars, we're trying to go to the next step. So today we'll be discussing about who can go to court. In the next seminar, we will be discussing about what can you discuss when you're in the court and what type of review you can get from judges. And then finally, in the third seminar at the end of February, we'll be discussing about the type of orders that you can get from the courts to enforce stronger action from governments to fight pollution. So in today's webinar, we'll be going through three key parts. We will start with a general introduction on the Air Quality Directive. So I will try to walk you through the key provisions of the directive because it's important to understand how the directive works in order to better understand how to use it in courts. Then we will move to a second part on a review of the case law of the rulings from the Court of Justice of the European Union on the right to clean air and standing. And then finally, we will close with a third part, trying to go a bit deeper and show you some examples from national jurisdictions, try to show you what type of challenges citizens may find when trying to go to court to enforce the right to clean air, but also how some judges are following good practices and letting citizens go into court. So let's start with a short overview of the Air Quality Directive. And I think it's important to start noting why there are rules on air pollution. And the main reason is rather simple. Air pollution is the world's largest single environmental health risk. According to the Lancet Commission, in 2012 alone, more than 6.5 million premature deaths were related to harmful level of pollution in the world. And the situation is quite serious also in Europe. Still, the WHO estimates that more than 90% of children globally live and grow up in areas with harmful level of pollution. So it's important to try to reduce the levels of pollution. And that's why, because when you breathe air pollution, it doesn't stay only in your lungs, but it gets in your body and it affects almost virtually all organs of the human body. Air pollution has both short-term and long-term impact on the pulmonary system. It is linked to lung cancer, to cardiovascular diseases, to asthma, and is usually the most vulnerable population, like children or elderly people, who suffer the most the impacts of air pollution. That's why the European Union, since the 1980s, started to introduce rules to try to reduce the levels of pollution. And so let's start to see what the current rules on air quality are in Europe and what we can call the theory. So just looking at the provisions. The most recent legislation on air quality is the Air Quality Directive from 2008, number 50. And this is an interesting piece of legislation because it combines both substantive and procedural rules. The key substantive part of the directive is the setting of limit values. These are maximum concentration of pollutants to be ensured in cities. But there are also a number of procedural rules which are equally important because they help authorities to achieve the final outcome of reducing air pollution. So there are rules on how authorities should monitor and gather information on air pollution, rules on how this information must be made available to the public, and finally rules on air quality plans, so on the policies and tools that authorities need to implement in order to achieve the final objective of improving air quality. So let's take a closer look. Limit values are set in Article 13 of the directive. It is important to stress that this is an obligational result. According to the directive, limit values are level fixed on the basis of scientific knowledge with the aim of avoiding, preventing, or reducing harmful effects on human health or the environment as a whole. And these limit values need to be attained within a given period and not to be exceeded once attained. So these are very strong binding obligations. And really, it's not that usual that in environmental field we have these strong obligations. Usually, the targets in environmental matters allow governments and authorities to balance the achievement of a target with other consideration on politics and economic costs of the measures. But the important thing of the Air Quality Directive is that this obligation is an obligational result, it needs to be complied. There is no excuse for breaching the limit values. In this table, you can see a quick overview of the key limit values for the most concerning pollutants, with the levels of pollution insured and the deadlines for compliance. So these are, for instance, nitrogen dioxide. This is a harmful gas coming mainly from diesel vehicles in European cities. And the deadline for compliance was in January 2010. And then you'll see for particulate matter, PM10 and PM2.5, depending on the size, and the smaller the particles, the most harmful, these compliance deadlines were in 2005 and 2015. But it is important to note that the level of protection ensured by European provisions is not completely in line with the recommendation of the World Health Organization. So you can see that in particular for PM, the levels in the limit values of the European Union are almost double or even more than double the recommendation of the scientific world. That's the reason why this happened is because when adopting the rules, the Commission, the European Parliament, and in particular the Council took into consideration not only the science, but also economic factors or the achievability of the limit values. We need to remember this when going to court, because the limit values are binding and they already factored in the political consideration. So now, after the compliance deadline, there shouldn't be any further discussion about political factors or technical complexity to achieve the limit values. And another key provision is Article 23, which is the provision clarifying what air quality plans are. And again, we see an obligation of result, a very strongly worded provision. According to Article 23, whenever there are exceedances of the limit values after the deadline for compliance, authorities must adopt air quality plans setting out appropriate measure so that the exceedance period can be kept as short as possible. Again, a very strong obligation for member states. And then finally, as I mentioned, there are also an entire set of provisions on air quality monitoring, on how authorities should gather information on air pollution. So there are rules on the type of regime for air quality monitoring and the minimum number of monitoring stations and where exactly you place monitoring stations. As you can guess, it's not the same to measure air quality close to an industrial plant, close to a busy road, or in a park in a city. The levels of pollution can change quite radically. So it is essential that there are monitoring stations to capture data in the areas where the highest concentrations happen within the cities. Again, quite clear obligations for the member states. So I know that I've already provided you a lot of information in short time. Unfortunately, I don't have a full session to just describe the directive, and maybe you would be bored just to listen to this part. But if you're interested to know more about the directive, we published a cleaner handbook, and you can find it at the following link. So we have seen the theory of the directive. We have seen that we have binding obligations to comply with certain limits of pollution that entered into force many years ago. So now we will expect to be in a situation where air pollution is not a big deal all across Europe. But let's take a closer look to what is the reality all across Europe. So you can start going to this website from the European Environment Agency that created an air quality index providing live data on air pollution from all the monitoring stations across Europe. You can see this is a screenshot from last Saturday, a lot of red dots and purple dots showing that there was very poor air pollution in vast parts of Europe. And this is, you can zoom in on any monitoring station. This is an example from Place de l'Opéra in Paris. And you can see data not only from the specific moment when you're checking, but also on the previous days and weeks. Still, the European Environment Agency publish as well every year an air quality report collecting data by all member states and showing what is the status of compliance with the directive. So the latest report from 2019 provides information about levels of pollution in 2017. So let's take a closer look. For PM10, we can see that there were wide exceedances, especially in Central and Eastern Europe. You can see in Poland, it's basically only red dots with exceedances. And the north of Italy, it's a very severe level of pollution. And PM pollution is mainly related to traffic, especially older diesel cars, but also combustion of wood and coal for domestic heating and in industry. For PM2.5, the situation is rather similar with exceedances, again, in Central and Eastern Europe and north of Italy. You see just less red dots because the levels of protection ensured by European law are not very ambitious. But if you consider that also the light blue and purple dots are exceedances of the WHO guidelines, you can understand that the levels of pollution are still concerning. And then finally, for nitrogen dioxide, you can see that mostly all cities, big cities across Europe have problems with exceedances. This is mainly related to pollution from diesel vehicles in cities. And this is obviously very severe impacts on the health of the people. The European Environment Agency estimates that more than 370 premature deaths occur every year because of exposure to high level of pollution. So we are in a situation where we have binding rules on air quality limits. Member states have had many years to comply, but unfortunately, many years after, we're still in a situation with widespread exceedances all across Europe. And the solutions to air pollution exist. We know, for instance, that low emission zones in cities or banning the burning of solid fuel for domestic heating can be very effective in improving air quality. Now, what lacks is the political will of authorities to implement these solutions to, in the end, protect people from air pollution. So there is a huge enforcement gap all across Europe. And that's why we believe that it is important for citizens and NGOs to engage and try to improve the situation, put pressure on authorities. So the final point to consider is that unfortunately in the Air Quality Directive, there is no express provision on access to justice. So the directive itself doesn't clarify who can go to court to try to ask authorities to comply with the directive. Even if there is no express provision, we can use the Aarhus Convention, namely Article 9.3, but unfortunately, as found by the DARPO report a few years ago, implementation of the Aarhus Convention, the access to justice provision at national level is diverging, random, and inconsistent. So it's not always easy to go to court. That's where I think it is essential to stress that the case law of the Court of Justice of the European Union can provide very valuable tools to help citizens and NGOs to go to court and enforce the right to clean air. So let's move to the case law of the Court of Justice. It all started in the late 80s and early 90s with a series of cases from the Commission against Germany. These were not cases brought by citizens or individuals. These were rather cases that the Commission was bringing to try to make sure that Germany transposed properly limit values for air quality or water quality. And the German government was actually refusing to transpose the limit values in binding national law, and they considered that just having guidance for public authorities was enough to make sure that the quality of air and water would improve. And that's where this first ruling from the Court of Justice is important, because the Court of Justice already, in this ruling in case 59 of 89, clarified that limit values are imposed specifically to protect human health. They're essential to protect human health. So that's why whenever the exceedance of a limit value could endanger human health, the persons concerned must be in a position to rely on mandatory rules, and that's why they need also to be able to rely on these rules, and where appropriate, rely on them before the national courts. So these were not cases brought by individuals, but this part of the ruling already showed the way for suggesting the citizens should be able to enforce limit values. This ruling remained in a drawer for many years, and no one used it until Mr. Dieter Janecek, a member of the Green Party in Munich in 2007, decided to try to use this ruling and try to go to court. The situation in Munich in 2007 was with severe exceedances of PM10, especially in Landshütter Allee, which was a big road not far away from where Dieter Janecek was living. And at the time, we still didn't have the current directive, so the Air Quality Directive from 2008, but there were already provisions on limit values from a previous directive from 1996. Mr. Janecek tried to go to court and request the competent authority to adopt short-term action plans to reduce the levels of PM10, but he faced resistance from the German courts because it was the first time that a citizen was trying to do that, and it wasn't clear whether that was possible or not. The matter, in the end, was referred to the European Court of Justice. This is case C-237 of 2007, Janecek against the Free State of Bayern. And that's really a fundamental ruling for access to justice widely, and specifically for access to justice and the right to clean air. In this ruling, the Court of Justice made it clear that where there is a risk that limit values may be exceeded, persons directly concerned can require the competent authorities to draw up an action plan. This ruling, however, was on the previous directive, so it didn't say anything about Article 23 and the obligation to comply in the shortest time possible. And it was also a case brought by an individual. It wasn't clear whether, for instance, NGOs could go to court, but already a fundamental step forward by the European Court of Justice. Having received this ruling, ClientEarth in 2010 decided to try to use it to bring an action in the United Kingdom immediately after the entry into force of the nitrogen dioxide limit values on the 1st of January 2010. At the moment of time, 40 out of 43 zones across the UK were exceeding the limit value for nitrogen dioxide. There were air quality plans adopted, but in 16 zones, compliance was not projected until after 2015. And for instance, in London, compliance was not projected until 2028. That was 18 years after the deadline for compliance. And we thought that that was hardly as soon as possible as required by Article 23 of the directive. So we decided to go to court and require judges to order the authority to step up the level of ambition and adopt better air quality plans. Unfortunately, it wasn't easy. Again, judges don't like to interfere with political decisions of the government, and requesting the government to, for instance, introduce restrictions on diesel vehicles is something that many judges perceive as not the role of the courts. And that is exactly what was the first ruling from the High Court. The High Court in the UK is actually the court of first instance. The judge acknowledged that the government was in breach of the directive. However, he stressed that there were serious political and economic questions. It was not the role of the judge to tell to the government how to use resources on one policy on air quality. And on top of that, the court considered that the European Commission can bring infringement action enforcement. So it's, according to the High Court, it wasn't the role of the national judges to enforce European environmental role, but it was the role of the European Commission. Obviously, this type of ruling raises doubts about the rule of law, because if there are provisions, binding provisions in one directive, the government should be held accountable in courts. And that's why we kept appealing the decision until up to the UK Supreme Court, that again decided to refer the question to the European Court of Justice on how to interpret the Air Quality Directive, and in particular to clarify what should be the role of national judges. Again, the Court of Justice issued a very strong ruling upholding the right to clean air. In case C 404 of 2013, ClientEarth against the United Kingdom, the Court of Justice clarified that both natural and legal persons directly concerned by the exceedance of the limit values must be in a position to require the competent authority, if necessary, by bringing an action before the courts to establish an air quality plan, but not any air quality plan, a specific air quality plan which complies with Article 23 and the requirement to achieve compliance in the shortest time possible. So again, a ruling in line with the Janecek case in the previous jurisdiction from Germany, confirming that also for the new directive, citizens and NGOs have a right to clean air, and they can go to court to not only ask the authority to adopt an air quality plan, but they can go to court to review the content of the plan. And then finally, there is another point which I think is interesting. All these cases were about exceedances of the limit values and the obligation to adopt air quality plans, but there is another aspect of the directive which is essential, which is how authorities monitor air quality. And so again, ClientEarth decided to help a group of citizens in Brussels to bring a challenge against the authorities because they were not monitoring air quality properly. In this map, you can see a dispersion model of nitrogen dioxide in the city of Brussels. You can see the dark red parts are the main roads with the highest level of congestion and obviously also of pollution. But unfortunately, you see from this map, Station XL is the monitoring station in the network, which at the moment is presented as the station with the highest level of pollution, is not in an area with dark red concentration. So we went to the court and requested the judge to order the placement of additional monitoring stations in the most polluted parts of the city. This time the Court of First Instance of Brussels decided to refer immediately the question to the European Court of Justice, and we received the ruling last June in case C723 of 2017, ClientEarth versus the region de Bruxelles. And again, we found the Court of Justice of the European Union ready to protect citizens and the right to clean air, because the Court of Justice clarified that the Air Quality Directive rules on the location of monitoring stations contain clear, precise, and unconditional obligations, which means that they can be invoked by individuals against the state. And the Court of Justice clarified that even if this rule may be complex and technical, that doesn't mean that the courts should not step in and order authorities to do more to better assess levels of pollution in a city. So this group of rulings really helps citizens to fight for better air quality in cities. In the three rulings, the Court of Justice clarified that citizens have the right to request the adoption of the plan, to request the review of the measures in the plan, and if necessary, also to request the installation of additional monitoring stations. And the important part is that rulings of the Court of Justice of the European Union are binding on all authorities and judges across Europe. So using these rulings and these precedents, ClientEarth is now helping citizens and NGOs to fight for the right to clean air in 10 jurisdictions all across Europe. We are having, in some jurisdictions, really positive development. So in the next webinars, we'll be discussing about the content of our actions, for instance, in Germany and in the UK. But I think today, as we're discussing about standing, we want to provide you an overview of cases where we are still finding barriers to the right to clean air. And one of these jurisdictions is Poland. So I'll pass it over to my colleague, Bolek, to discuss about the experience in Poland.
Thank you very much, Ugo, for your very good presentation. And just before I share, bear with me for a second, my screen so that you can see the plans that are adopted in Poland. The law, as it is currently stated, requires air quality programs to be implemented and updated every 3 years, which in practice means a requirement to achieve the limit values and to undertake effective action.
Hold on a second. I think
yes.
We're not seeing your screen.
You're not seeing my screen at the moment?
No. So
that's quite odd, because I am. It does say on my screen that I am sharing my screen.
We see your screen,
perhaps
but not the slides.
You don't see my slides. We'll see. Okay, I see. So perhaps it would be easier, Ugo, if because I only have a few limited slides, for you to show your screen, and then I will be able to just ask you to move the slides. Would that be a better way of doing this?
Let's try this.
Okay. Okay. So just let me know if I can continue. Yep. Yes, okay. So I can continue. Thank you very much. Sorry for that technical difficulty. So as I was saying, the air quality programs in Poland, they are formally adopted, but because their substance is so vague in most cases, they do not allow the Polish authorities and Polish state to meet its European obligations or obligations under European law to have air quality or air of the quality required under EU law. So in reference to what Ugo was saying just a little while ago, we have both a problem with substance in that in Poland the limit values are not attained, and also procedural problems relating to what is actually included in the air quality programs in Poland. Now, if I can ask for the next slide, then you will see from that next slide that in Poland, air quality programs are local laws. They are not decisions. In other words, they are not adopted by the government in the form of a decision, which has the practical effect of limiting the individuals or the type of entity that can actually challenge the air quality plan. In the case of administrative decisions, all you need to do in order to challenge that legal instrument is to show that the decision in some way relates to your legal interest. So it doesn't actually have to affect the legal interest at the moment that it is issued or implemented. Local laws, however, because they have a different legal regime applying to them under Polish law, local laws, in order for an individual to be able to challenge a local law, such as an air quality plan, the individual needs to show that the local law not only relates to their legal interest, but actually affects it materially and negatively. So the legal interest, in order for that to be possible, must be individual, so it has to be a specific right or an obligation concerning that individual that is being imposed or given to them. It must be concrete, and it has to be what we call in Poland actual, which means that it has to exist at the moment that the law is being implemented, or is being adopted and implemented. So you need to demonstrate additionally, in the case of local laws, that your legal interest, your individual and present legal interest, is being violated. What that means, in terms, example for ClientEarth, what that means in practice is that an air quality plan cannot affect the legal interest of an NGO. There's no right that the NGO has, an NGO or an entity like an NGO has, that can be demonstrated as being violated by a plan that is supposed to work in the future, and that in its substance is supposed to say what the authorities are supposed to do in order to improve air quality. So in 2017, and this is the next slide, if you may. Thank you. In 2017, a Polish citizen and ClientEarth challenged an air quality plan for the region of Silesia. I should say that ClientEarth was an intervener in this case, not the actual challenger, but for our purposes, let's say the challenger. We alleged basically what Ugo said could be alleged under European law, and that is that the measures in the air quality plan were at that time and still are inadequate to attain a situation in which the limit values will be reached in the shortest possible time. And the reason for that is because the duties and the obligations of public authorities in the air quality plan were vague. They were not stated in a way that would allow authorities to undertake acts necessary to bring the air quality in line in the shortest possible time. For over 30 years, that the air quality is terrible in that part of the country particularly, and that the success have been unable to problem. ClientEarth was, as I said, these types of cases have no standing by themselves. So we had to find an individual who at least could make the case that he was affected by the air quality plan. So if we move to the next slide, excuse me, it's just an overview of the arguments that we made, and that is that we relied on the Court of Justice judgments that Ugo mentioned, And in so doing, we argued for a broad, favorable, EU favorable reading of the provisions which should be adopted and which should be implemented in this case specifically the Polish provisions on standing. Our argument was that they should be read broadly so as to allow an individual in this case to have standing. And if the court would not be able to rule immediately on this issue, we asked for a preliminary ruling or for a petition for a preliminary ruling by the CJEU, or the Court of Justice of the EU. And unfortunately, and this is the next slide, unfortunately, at the beginning of 2018, the Supreme Administrative Court denied that the individual had standing, stating, as I foreshadowed a few moments ago, that the air quality plan in Poland is addressed only to the authorities. It imposes no burden and no obligation on the individual. And therefore, for those two basic reasons, it cannot be said that that air quality plan is evidence of a violation of the legal interest, even though it does relate to the legal interest, but does not violate the legal interest as far as the court is concerned. And as far as the preliminary ruling by the Court of Justice is concerned, the Supreme Court said that it had no doubt how to read the Polish provisions, and so no ruling by the CJEU was necessary, particularly since a probable ruling would require the Polish court to go against long-standing judicial precedents in Poland and the wording of the Polish statute. So no reference to the CJEU was made. But, and this is we in other areas, although it seems that at least on a national level there is no hope. I wrote the Nations for Hope that we said there's a bit more into this in the next presentation in a few weeks. But we do have other areas of the law where we can initiate cases not concerning air quality plans, but relating to the air quality problem in Poland. But I should mention perhaps a very important issue or an event. ClientEarth in March 2019 asked the Commission to undertake formal action against Poland for its failure to allow individuals to have access to justice in cases where the air quality directive is being infringed by Poland, or relating to the fact that Poland infringes the air quality directive, which incidentally the European Court of, or the Court of Justice of the European Union has already ruled on in 2018 in February, and in which the European Commission has sent a letter of formal notice to the court in July 2019. So ClientEarth is undertaking action on a European level, as the Commission is concerned, in order to make sure that Poland changes its law to allow individuals to have access to court in air quality cases. So thank you very much for your time.
Thank you, Bolek. And I think that it's very good to link with this final slide that you had. So we have seen that in Poland, unfortunately, there are still barriers to access to justice that make it very difficult for individuals to take action and try to force authorities to adopt better air quality plans. But that doesn't mean that citizens and NGOs should stop. And actually, it's always good to try and see if there are other entry points and other ways to try to overcome the barriers. And that's actually what happened in France. So France, as many other countries in Europe, had severe exceedances of limit values all across its territory. And in 2010, Les Amis de la Terre tried to, for the first time, to take a legal action, and they challenged the air quality plan for Paris, taking action against the local authority. Unfortunately, both the administrative court in first instance and then the Conseil d'État, the top court in administrative issues in France, on appeal, they rejected the action, holding that air quality plans are just one among several tools. Competent authorities have wide discretion when selecting measures. And finally, in the end, according to French judges in this ruling, the adoption and implementation of the air quality plan is only an obligation of means. So basically, it's not the role of a court to check whether authorities are complying with the directive and to give an answer to legal actions brought by NGOs. That was basically refusing standing to challenge the air quality plans. But Les Amis de la Terre didn't stop. In 2015, ClientEarth and Les Amis de la Terre tried to start a new approach, and this time it was decided to take action not against the local authority, but against the French government as a whole, as an entire entity, because there were exceedances in 16 zones and agglomerations all across France. And in this action, it was essential that, as already made in Poland and in all the other countries, we relied heavily on European law and on the rulings of the Court of Justice. And I must say that luckily, in July 2017, the Conseil d'État decided to overrule his previous decision, and departing sharply from the previous refusal of standing. They followed the case law of the Court of Justice of the European Union, in particular the recent, by then, ClientEarth case, and the Conseil d'État held that the Air Quality Directive sets an obligation of results on authority. That is true that there is discretion of authorities, but this discretion over the content is limited and subject to judicial review. And in the end, they ordered the government to adopt new air quality plans by the end of March 2018. So, as you will see also in the next seminars, even in the UK and Germany, it was difficult to bring the action at the beginning. We had to face resistance on access to justice, but if you persevere and you try different approaches, you may be able to find a good hook, a good approach to challenge the failure of authorities to improve air quality. So, concluding, European law sets clear and binding rules on air quality, but unfortunately, many years after the entry into force of the directive, there are still widespread breaches all across Europe. That shows that having good rules is essential, but is not enough if they remain on paper. So enforcement is a key part of protecting the environment and the health of people. The case law of the Court of Justice of the European Union provides now very strong tools for individuals and NGOs to protect their right to clean air before national courts. We have seen the Janecek case, the ClientEarth case, and most recently the Krajniec case that provide the full spectrum of legal actions that individuals and NGOs should be able to bring before national courts. Unfortunately, there are still a number of member states where there are serious barriers and challenges to the will-be litigant and to individuals that want to protect the right to clean air. So that's why it's essential to have the good ruling of the Court of Justice of the European Union, but it would be even better to have express provisions in the directive granting expressly access to justice to citizens and NGOs. So that's all for our first webinar. You can ask questions. We still have 15 minutes, so you can type your questions. I've seen there are already a couple, so now we'll approach them. But as a reminder, there will be 2 other seminars on the 12th of February and on the 26th of February dealing with other aspects. So on how to have substantial review of the plans and on the type of orders. So, as regard the question, so I see the first question is about the interpretation of Article 23 of the directive, and especially the part where it requires to achieve compliance as short as possible. So the question is whether case law has clarified what as short as possible means, so whether 1 month, 6 months, or 1 year. Well, that was one of the preliminary questions referred in the ClientEarth case, case 404 of 2013. Unfortunately, in that opportunity, the Court of Justice didn't provide a clear indication about what as short as possible means. That doesn't mean that there is no case law on the point. We will see this part more closely in the next seminar, the one about substantial review by courts. But just to provide some general indication about what you can expect in the next seminar, there's been rulings from the Court of Justice in infringement actions against Italy, Poland, Bulgaria, France, among others, where the Court of Justice has provided an indication on how to interpret whether air quality plans comply with the directive or not. And there is also some very useful case law from national courts in Germany and in the UK in particular, where national judges clarified that as short as possible means that authorities cannot consider economic factors or technical complexity when selecting the measures, and how authorities should go about picking the most effective measures. So I hope this general answer will be enough for the moment, but I invite you to attend also the next seminar, where we'll go more into detail about how to interpret as short as possible and how to use both the directive and the case law to challenge the content of air quality plans. Then I see another question about civil law litigation. So a question about whether there is any national judgment establishing a causal link between the client's medical condition and air pollution. As far as I know, there hasn't been any such ruling yet, but there's been some interesting cases. So there is an ongoing inquest in the UK on a case, a rather unfortunate case where a young girl, Ella, died because of a asthma attack in London. And now the mother is is undertaking legal action, trying to open an inquest on the causes of the death of her daughter, and try to establish whether the levels of pollution in London were responsible for the event. There's been a number of legal actions in France where citizens have tried to claim damages because of the impacts of air pollution. There's been, for the moment, some first instance rulings clarifying that there is a clear breach of the obligation by the government to comply with the limit values, but at the moment, the French courts have not established a causal link entitling the individual to claim damages. And I think maybe, Bolek, may be useful for you to mention the civil litigation cases in Poland.
Yes, I was actually, my last slide, I believe, mentioned those. I was going to talk about them a little bit during the next presentation, but I can do so now. For many years in Poland, there was this line of jurisprudence that said that even though are clear violations of European law and domestic law concerning limit values and air quality, there is, as the question probably is intended to state, there is no causal link between that and, or there's no demonstrable causal link between that and a person's medical condition, or even the possibility of a person having some sort of an illness or ailment due to poor air quality. In the past few years, however, there's been a change in the jurisprudence, at least on a first instance level. We're still waiting for the second instance court to rule on this, but in the past few years, a few individuals have gone to court stating that they live in areas where air quality is very poor, and simply for this reason, and the fact that the state is not meeting its European obligations, simply for this reason, compensation is required because there is a presumed link between poor air quality and a breach of a personal good such as health. And these individuals have been awarded damages in the first instance. Currently, that is on appeal. So at least in the civil courts, we've seen quite a change in jurisprudence. We'll see whether that continues.
Thanks, Bolek. And finally, I see a question asking us to provide a view on what is our assessment of the impact of Brexit on enforcement of the air quality laws in the UK. Yeah, that's a really good question. I think the starting point, as I hope you may have got from the presentation, is that European law has been essential to drive action on air pollution, and the fact that we have binding rules on limit values and on the obligation to adopt air quality plans to comply in the shortest time possible have provided valuable tools for citizens and NGOs to fight in courts and push governments to do more to fight air pollution. The initial impact should, I'm not a UK lawyer, so obviously I can put you in touch with our lawyer in the London office, but the starting point is that in the withdrawal agreement and the immediate impact is that European law will remain in force in the UK. The issue is that after Brexit, there will be nothing preventing the UK government to change the rules and lower the level of ambition. So that's why it is essential that in the Environment Bill there would be binding rules to reaffirm the limit values and ideally move towards compliance with the WHO recommendation. The other part that is essential to mention is that having the possibility of preliminary rulings to the European Court of Justice and the possibility of enforcement from the European Commission has been essential to ensure action by governments. So that's again where Brexit creates the risk of leaving a gap. That's why it would be essential to have an environmental watchdog who can step in and take enforcement action against the UK government to hold them accountable to air quality laws. And recently we've seen proposals from the government to allow even lower courts in the UK to depart from the case law, from the existing case law of the European Court of Justice. That's again very concerning because we've seen that the case law of the CJEU has been essential to establish the right to clean air of citizens and NGOs. So we need to be very careful not to allow any weakening of the rights of people. So unless there are any further question, I would really like to thank you for your interest on this matter. I will invite you to attend the next seminars where you will get some further insight and food for thought on how to litigate for clean air before your national jurisdictions. And just thank you all and have a nice day.